programs in FIDIC. We're very pleased to have so many of you attending this presentation today, and thank you all for joining us. My name is Michael Gallucci, and I manage the chartered surveying firm MPG, which has offices in London, Dubai and Riyadh. I'm a chartered QS and quantum expert witness with a law degree in international arbitration and contract law, and have been working in the UK and Middle East since 1988. Our team at MPG includes quantum and delay experts, claims and cost consultants, and legal specialists in dispute resolution and insolvency. I'm assisted today by Michael Blackburn, who is a construction engineering legal expert in domestic and international disputes. He was head of construction engineering disputes group at DAC Beechcroft for the last 12 years and has been practicing law since 1981. He advises on procurement and contract formation and has knowledge of all of the major contract forms. He's also familiar with all forms of dispute resolution, including mediation, adjudication, arbitration, litigation, and through the courts. He has worked for clients from all over the world, including Europe, North and South America, the Middle East, and Africa, and is listed on the Legal 500 as an expert in construction. So without further ado, I'll pass over to Michael, who's going to talk about concurrent delay. Off you go, Michael.
Yes. Good morning, everybody. Also, just to say, I'm an accredited TEXA adjudicator, and I also sit not only as an adjudicator, but also as a mediator as well. So today we're going to be discussing concurrent delay, which is a surprisingly complex topic. In essence, it is where a construction project is delayed by two events at the same time. One event being the responsibility of the employer, e.g. the instruction of variations. The other event is the responsibility of the contractor, e.g. insufficient resources on site. The problem is that any tribunal is going to want to know which one has caused the project to be delayed and how the effect of such delay should be decided. Should the contractor be liable for liquidated and ascertained damages due to his insufficient labour, or should he get an extension of time for the delay caused by the variation? Should the contractor be entitled to loss and expense during the time he was delayed by the variation, or should he not, on the basis that he did not have sufficient labour to complete the works? So these are the topics I'm just going to briefly discuss with you, which is concurrent delay, a definition, causation, concurrency, and how the courts in England and also in Scotland and around the world have attempted to approach these subjects. And also just to reassure you that there can be concurrency clauses, which is why, as ever, with all construction matters, and particularly disputes, you must check the clauses in your contract. And then just one or two conclusions. Next slide, please. So a definition of concurrent delay is basically a period of project overrun which is caused by two or more effective causes of approximately equal causative potency. And that's the important point. It's this equal causative potency. Next slide, please. So the effect is key. It's not necessarily when the delay took place. The effect is key. It is the delay that is concurrent, not necessarily its cause. The delay, it must be critical. And what the courts have struggled with is in attempting to apply simple English legal principles to two causes of delay. Because what the English courts will want to do, and English law will certainly want to do, is were the losses caused by the breach of contract by the contractor or caused by the relevant event? And that's what the courts will struggle with. And that's often called the but-for test. So if the project would have been delayed by the contractor, by the contractor having insufficient resources, but for the variations instructed, then we realize that the contractor in those circumstances, it can't be said that he's entirely to blame for the failure of the project to proceed satisfactorily. Plenty of issues about what is true concurrency. And just going to the next slide, please. So there are courts have approached this matter on different bases: the dominant cause, the malmaison approach, apportionment, and what is now effectively the current approach. So just looking at dominant cause, next slide, please. In essence, if there are two causes, one the contractual responsibility of the defendant and the other the responsibility of the plaintiff will succeed if he establishes that the cause for which the defendant is responsible is the effective dominant cause. Which causes dominance is a question of fact, solved by the mere point, not by the mere point of order in time, but it is decided by applying common sense standards. Now that was written in 1991 edition of Keating. What in essence there was that we spent a lot of time trying to determine which of the two causes was the dominant cause. The problem arises when you have, as I say, two matters of equal causative potency. So they're both causing the delay. And that if you strip one of them out, if you ignore one of them, did the other cause the delay? The answer to that is yes. And that applies in relation to both items. So why should the parties be taken to have agreed to this principle? Then next slide, please. So it's agreed that the malmaison approach, which was set out effectively by Dyson J, which is that if there was no work was possible for a week due to inclement weather, but the contractor has shortage of labour, what should happen in those circumstances? So the contractor couldn't have worked during that week because there was inclement weather. They didn't have the labour to do it anyway. In those circumstances, the courts have decided that the contractor should get an extension of time, because that would be the fair and reasonable approach adopted by the architect in determining whether or not he should get an extension of time. This would mean that the contractor would not have liquidated and ascertained damages levied against him. But also, it would be seen as being somewhat unfair if the contractor would be entitled to loss and expense for the period whilst he was not working. And clearly, that would seem to be somewhat unreasonable if, in fact, he couldn't work because he had a shortage of labour. So just in relation to this malmaison approach, it's time but not money that the contractor gets. This obviously potentially favours the contractor because clearly he doesn't get levied with liquidated and ascertained damages. It had been generally accepted that the test in true concurrency situations was the circumstances in malmaison would apply. But true concurrency is very rare. What I mean by true concurrency, these are two events that start at the same time and have the effect at the same time of causing delay to the project. What is far more common is that you have an element that delays a project, and then another element that takes place after that also delays the project at the same time. Judge Seymour favoured a very narrow view of true concurrency, but he considered that it was extremely rare for it to occur, i.e. this idea of you having a item that was the delay of the contractor and the delay of, and then a separate item that's delayed by the employer at the same time, having the same effect at the same time. Next slide, please. In Scotland, they have found this approach to be somewhat difficult to justify and consider that apportionment should be applied, so that where you have two causes of delay that are concurrent, then the architect could fairly and reasonably apportion the delay to one or more of the elements that's caused the problem. This will involve some form of culpability test being applied to one or other of the events. This is a somewhat difficult concept under English law. So what you'd be trying to say was that, look, the inclement weather, for example, was not really, the employer wasn't necessarily culpable as such for the inclement weather, and therefore in some way the contractor should have to have levied against them liquidated and ascertained damages, even though they couldn't work during the inclement weather period. Obviously, that's inconsistent with what's actually written into the contract, and therefore the English courts struggle with this apportionment route. England generally tends to struggle with Scotland generally, but that's probably a different topic for today. In the Gulf, the Scots law, which is in part a civil law system, has been applied. So we have seen circumstances where apportionment is attempted, and certainly in relation to FIDIC, where the duty of the engineer is to be fair in clause 3.5 of FIDIC. Again, this is it makes the work so much more difficult in terms of trying to determine, as I say, where you start applying culpability for the different causes of delay. Next slide, please. So moving on to where the courts have been approaching the matter, for example, in the De Beers case, this is another example of a contractor being entitled to an extension of time, but not being entitled to his loss and expense, applying the but-for test, i.e. that if the contractor can't say that the loss and expense has been caused entirely by the inclement weather in circumstances where he didn't have work, didn't have the resources available to complete the project. And then in, next slide, please, in Adyard Abu Dhabi, basically this is Hamlin J rejecting the apportionment approach which was applied in Scotland. And then next slide. Then, rather interesting, this is the reason why you need to read your contract. In this North Midland building case, the contract disallowed extensions of time for the contractor where there was concurrent delay. So this would mean that if there was concurrent delay, of an example of the type I've given earlier, i.e. Inclement weather, and the contractor is actually delaying the project because he has not got sufficient resources, then the contractor won't get an extension of time. The courts struggled a little bit with this on the basis that didn't this mean that you had what was effectively called applying this sort of prevention principle, where the contractor was prevented from getting an extension of time. Was that fair if it wasn't his fault that he was being prevented from completing the works due to the inclement weather? But the concurrency clause was found to apply, and in those circumstances, the contractor did not get an extension of time. So moving forwards now to the most recent case, which appeared at the end of last year, where the judge really summed up where we are, saying that although there has been much debate as to the law in respect, in this respect, including submissions, counsel following the approach of first instance of, as I say, De Beers, and also in Hamlin and Aikenhead, the law appears to be settled in that we now have application of what's actually stated in Keating, that in respect of claims under the contract, depending upon the precise wording of the contract, a contractor is probably entitled to an extension of time if the event relied upon was an effective cause of delay, even if there was another concurrent cause of the same delay in respect of which the contractor was contractually responsible. And the important wordings in that clause, in that statement, is obviously depending upon the precise wording of the contract, which is why you need to see if there is what I would call a concurrency clause in the contract, i.e. a clause that addresses concurrent delay specifically. And depending upon the precise wording of the contract again, the contractor is only entitled to recover loss and expense where it satisfies the but-for test. Thus, even if the event relied upon was the dominant cause of the loss, the contractor will fail if there was another cause of that loss for which the contractor was contractually responsible. Next slide, please. So in summary, if the concurrent causes of delay, if there are concurrent causes of delay, the contractor normally gets time but not money. And importantly, concurrency clauses will not be defeated by the prevention principles. So you can have clauses that prevent a contractor from getting an extension of time in circumstances when they are not at fault for the delay to the works. So as ever, with all parties to construction contracts, it's extremely important that you ensure that you have correct record keeping. And also, it's also extremely important that you ensure that your program is properly updated. I know that in the NEC contract, there are obligations to make sure the program is properly updated. But one of the problems one always finds when undertaking disputes relating to delay, there invariably is not the records available to assist us as lawyers and experts in presenting the claim in a way that's going to ensure that you are successful. It's less important as to what is the methodology that's used. I know that there are very many different ways in which you can present delay. But what is key are the facts. So what the lawyers and the experts will always want is the best record keeping possible, and preferably programs that are prepared concurrently at the same time as the delay that's taking place so that you can show, based upon which you presented your delay analysis. Thank you.
Thank you, Michael, for taking us through concurrent delay. I'm just going to talk a little bit about implied terms regarding prevention and how it's covered in the UK and also in the Middle East, particularly Qatar. So we're just going to run through implied terms, the concept of Mezalzimit, and if you were at our last presentation, we also talked about Mezalzimat in the civil code, the prevention principle, applying the prevention principle to a civil law contract, and a bit of a summary. Okay, so implied terms. To a common law lawyer, implied terms are terms implied by statute, terms implied by custom, terms implied by reasons of business efficacy, and terms implied because in contemplation of both parties to the contract. If you want to get your old law books out and look at the officious bystander test, you'll understand the terms implied in the Moorcock and Liverpool City Council and Irwin, and Mr. Blackburn, who's just walked off the set, could tell us all about that at a later date. This concept is alien to civil law systems. This is a common law implication of terms. So the distinction may be a subtle one, but rather implying terms, we have to look at the relevant laws to see what additional terms are to be treated as applying to a contract, rather than implying a term into a contract. So the test is the necessary obligations, and these are the indispensable requirements to cooperate and not to prevent performance. So implied terms in the civil code is the mother of all laws, as they say in the Middle East, and the additional obligations apply to the manner of performance of a contract and stem from a pre-civil law concept and ultimately an Arab and ultimately Sharia concept, which is transliterated as Mezalzimat. So Mezalzimat in the civil code, Qatari Civil Code Article 172. So these are effectively the implied terms. The contract must be performed in accordance with its contents and in a manner consistent with the requirements of good faith. The contract is not confined to obliging a contracted party to its contents, but also includes its requirements in accordance with the law, custom, and equity as per the nature of the obligation. So the Qatari Civil Code wants you to deal with your contracts and your contractors and your employers on a basis of good faith and to work together to achieve the contract. Article 246 of the UAE Civil Code also says the contract must be performed in accordance with its contents and in a manner consistent with the requirements of good faith. And differently to Qatari, it says the contract shall not be restricted to an obligation upon the contracting party to do what is expressly contained in it, but shall also embrace that which is appurtenant to the virtue of law, custom, and the nature of the transaction. So your contract is not just restricted to the obligations set out in the contract, it is also to embrace the virtue of the laws, customs, and the natures of the transactions in the area, region that you're working in. So you have to be careful to ensure that you're operating your contract taking consideration of the civil code. So what does Mezalzimat mean in civil law context? It's the positive obligations. These are obligations that they want you to abide by and that want to work in a fair manner with the people you contract with. They want you to act in good faith. They want you to perform the obligation, the contract in accordance with the laws and customs and equities pertinent to the obligations in question. So these are positive obligations and how the contract should be performed rather than merely implied terms. So they step further than an implied term into you need to follow these rules, and they also expressly apply in statute. In the UK, English law, we have the prevention principle and in Holman Guppy in 1838, many years ago, which Mr. Blackburn was probably still around then. There are clear authorities that if the party to be prevented by the refusal of the other contracting party from completing the contract within the time limited, he is not liable in law for the default. So if the employer stops you doing your work and you can't get your job done within the time that you've been allowed to, you're not supposed to be liable for the default. It is clear, therefore, that the plaintiffs were excused from performing the agreement contained in the original contract. So in this case, the contractor was excused from performing the agreement, and the plaintiffs were therefore left at large, and they are not to forfeit anything for the delay. Obviously, there's been lots of movement in regards to delay, concurrency, etc., but the basic prevention principle stands back to 1838. It still holds good today. The essence of the prevention principle is that the promisee cannot insist on the performance of an obligation which he has prevented the promisor from performing. So this was Multiplex and Honeywell on the new National Stadium at Wembley, when Multiplex got in a bit of a kerfuffle with their BMS controls subcontractor, Honeywell, and issued programs to Honeywell and asked them to do work. And in 2007, many years after that original 1838 case, the prevention principle still holds good today. In the field of construction law, one consequence of the prevention principle is that the employer cannot hold the contractor to a specified completion date if the employer has by act or omission prevented the contractor from completing the work by that date. So instead, times becomes at large and the obligation to complete by the specified date is replaced by an implied obligation to complete within a reasonable time. So as Multiplex prevented Honeywell's from completing their work by the specified dates, Honeywell were then required, it was implied on Honeywell to complete the work within a reasonable time. And these principles that are set out here in regards to employers and contractors are the same as what you would have between main contractors and subcontractors. But you would say, but we have a contract and we have extension of time clauses. So it is to avoid the operation of the prevention principle that many construction contracts and subcontracts contain provisions for extension of time. And these are supposed to be used to deal with prevention. Thus, it can be seen that extension of time clauses exist for the protection of both parties to a construction contract or subcontract. And that was by Jackson J in 2007. So prevention principle in a civil law context. The analysis may be a bit different, but it should result in a similar outcome. It's not an implied obligation to complete within a reasonable time, nor is there a concept of time at large. These are alien to civil law tribunals and analysis. So if we look at Mustausimat, the indispensable requirements in accordance with which the building contract must be performed, it's Mustausimat that drives the concept of good faith and custom and equity to the nature of the obligation. Bear with me. Going further on the civil law context, an act of prevention by an employer, if it's not properly compensated, becomes a breach of the employer's obligations pursuant to Article 172 in Qatar and Article 246 in the UAE. So if the employer stops the contractor doing the work by the time that's supposed to be there, this is not a prevention principle, but it becomes a breach of those Mustausimat codes in regards to the articles in Qatar and the UAE, and compensation for that breach will be in accordance with the relevant provisions of the civil code. So Article 256 of the Qatari Civil Code says, if the debtor does not perform the obligation specifically or is delayed in its performance, he is obliged to compensate the damage caused to the creditor. So if the employer does not perform, if the employer holds up the project, if the employer delays the contractor, he is obliged to compensate the contractor unless it is proven that the non-performance or the delay was for an extraneous cause for which the employer is not responsible. It doesn't go to say what those extraneous causes might be, but that would be something for the lawyers to argue about, I guess, if these things get into an arbitration or litigation. Article 386 of the UAE Civil Code is similar. If it is impossible for an obliger to give specific performance on obligation, he shall be ordered to pay compensation for non-performance of his obligation, unless it is proved that the impossibility of performance arose out of an external cause in which the obliger played no part. The same shall apply in the event the obliger defaults in performance of the obligation. So very similar to the Qatari Civil Code. If the employer holds up the contractor, delays their performance, etc., and if it's deemed that the employer was responsible for that delay, then he must compensate the contractor. Article 692 of the Qatari Civil Code goes one step further in making clear how the obligations are connected with the prevention principle. 692 says, where performance of the work requires a specific action within a specific time period by the employer, but he fails to act within the time period, the contractor may demand the employer to act within such reasonable time as determined by the contractor. So the time for the employer to act switches to the contractor can now determine what a reasonable time period may be. So it gives the contractor an obligation to come back and tell the employer what is going wrong and how it should be dealt with. Where such time period expires without the employer's action, the contractor may demand termination of the contract without prejudice to his right to indemnity as applicable. So under the Civil Code, if the employer does not act, then the contractor may be able to demand termination of that contract. And these civil codes are above what you'll find in your FIDIC or your contracts in the UAE and Qatar. So in regards to Qatar, these the civil code we just spoke about, there's no real equivalent Article 692 in the UAE Civil Code. Article 692 of the Civil Code is mandatory provision of the Qatari Civil Code, so it cannot be omitted or overridden. So that case of the contractor going back to the employer and asking for reasonable time and for it to be allowed for termination to be requested is a particular Qatari Civil Code obligation and not a UAE one. All other construction parts of the UAE Civil Code are in Articles 884 to 889. In summary, analysis prevention, the GCC, is a breach of contract terms and also a breach of provisions which are pertinent to the contract, contractual breach and compensation under the code. And if you feel you have any issues in respect of these matters, the best thing you can do is get legal advice to establish the way forward. So thank you very much for your time. I hope you've enjoyed our presentation today. Michael and myself are still here, so if you have any questions and want to raise your hand or put them on the chat, we can deal with those. We have been asked whether we can share the slides at the end, which we will do so. We'll share a recording of today, and there's no questions popped up as so far, so if that's okay, we shall say goodbye for today and look forward to seeing you again. Thank you very much, Michael.
Thank you. Thank you. Goodbye, everybody.